Ladies and gentlemen, I'm going to go ahead and start this meeting. We've got a few members that are on their way. I'm going to go ahead and do a little of the preliminary work of the committee first. Committee members, we have a bill that was transferred to the committee today, House Bill 872 by Representative Rogers. I'm going to assign this to a three-member panel to work with the author on the language of this, and I would like for Representative Glanton, if you would work with Representative Green and Representative Lumsden. And Representative Waits, if she doesn't mind, if you would work with her. I'd be grateful for that. Maybe y'all can perfect this language on the peer counselors. Next up, I had made an announcement the other day, and because of a lot, unfortunately, as with every piece of legislation, a lot of misinformation is brought out. But I'd like to make a few comments on House Bill 907 because there has been a lot of description on the internet as well as through some of the publications. House Bill 907 deals with the new day of app technology and smartphones, something that I deem to be a public safety issue. Uber, UberX, Lyft, and a lot of the new companies that are providing for-hire carrier service, basically the new day of taxi limo work. There's a bill that's been dropped in, and this needs to be perfected. I will tell everyone in attention to this meeting today, this is not intended to put anybody out of business. It is basically a public safety issue. That if someone is picking your children or your wife or yourself up, whether it be on an app and a smartphone or whether it be a traditional conventional taxi, I believe that they need to have a background check, that they don't have a criminal record, and that their driving record should be scrutinized for the safety of the public. I would also think that that vehicle needs to have, that they need to have liability insurance, and that they're paying their appropriated taxes for that service. Now that's the general gist of what this bill should be able to do. The representatives from Uber, Lyft, and a lot of these technology companies, as well as the representatives of traditional taxis and limos, hope that they're working together. There's been three members of the committee, Representative Taylor, Atwood, and Hightower have been appointed to work with those folks. I would encourage y'all to start meeting with them as soon as possible, possibly the old-fashioned way, get them all together in the room, set them down, and just work it out. Very good.
I spent all afternoon meeting with them, and they're also scheduled to speak to Representative Hightower and Ms. Taylor about it, and then we'll gather them up.
Very good. My gratitude to you, sir. All right, while we're waiting on a few folks to come in, we've got several people who did not have a chance to finish the roster yesterday. I have bent the rules of the committee a little bit. We've had a couple of folks who just absolutely felt that they needed to speak today because some of them had made a trip down. And with that, I'm going to start calling a few folks. And if I might ask, while we certainly do believe in your Second Amendment right to be heard, I would also be grateful if, your First Amendment right. Yeah, duh. Your First Amendment right to be heard. If you could, brevity is of a premium since we're going to be moving forward with this. First off, from yesterday, Jamie Brownlee. Is Jamie Brownlee in attendance? Is she not here? Would that be you, ma'am? This wouldn't be someone who by chance spoke yesterday, would it?
No.
Well, then if they can come up, then
Well, I will.
come to the microphone.
My name is Sandra Mackey. I am a member of Trinity Presbyterian Church and a citizen of the city of Atlanta. I just want to speak in opposition to this bill, and I want to give as an example how ridiculous it is from the standpoint of my experience coming into this building today. I noticed that when I came into to this building for this meeting, I had to go through a check to make sure that I was not carrying a gun. But yet, this legislature is proposing that people be allowed to carry guns into my place of worship and into bars in which I think they are obviously, by the nature of the place, are in a position to actually lead to violence, simply because you have a lot of young people, you have a lot of alcohol, and I think this is just totally irresponsible of the state to put ordinary law-abiding citizens at risk. And I have heard all of the arguments that, well, people who carry guns are going to protect other people. I do not accept that, and I think if the legislature is going to allow guns in my church, they should allow guns in the state capitol where they work. Thank you.
Thank you. Thank you, ma'am. Barbara Antonopoulos.
Thank you for allowing me the opportunity to speak. Yesterday I was at the hearing and there was a lot of talk about the Constitution. The preamble of the Constitution reads, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution." This paragraph lays out the terrain within which the entire Constitution is to be carried out, clearly indicating that liberty be maintained within the context of societal unity, of justice, of tranquility, and the common defense and welfare. And all the time down here, you engage in this balancing act to determine the extent to which personal liberties fit within your obligation to protect the common welfare of the residents of Georgia. So I assume that you take your oath to do that seriously, and I have some questions that I would like for you to consider as your debate on this bill goes forward. You mentioned a lot about the Second Amendment, but I want you to ask yourselves if these foundational principles of the Constitution are also being used as criteria for establishing particulars of this bill. And since House Bill 875 maintains restrictions on carrying weapons in certain places, for example, courtrooms and in this building and the Gold Dome, what criteria have you used to determine which public gathering places should be considered safe for weapons and which should not be? Are you applying the same criteria thoroughly, logically, and consistently? I'm not sure that you are. Ask that of yourself, please. You're hired by Georgia taxpayers to address issues that are critical to us, while, of course, supporting the Constitution. Are your districts full of clergy and bar owners and college presidents who are coming by the dozens to you, asking to make sure that those who frequent their establishments can carry guns? Yesterday, Representative Powell mentioned senseless acts of violence and how every time such a thing happens, it erodes the rights of gun owners everywhere. And you seem to imply that that was an important rationale to consider in considering restrictions on gun licenses for the mentally ill. I know several people who have suffered from mental illness for a long time, and I've seen firsthand why those who live with such maladies should not be carrying guns, because that would present a danger to those around them, which can lead to a tragedy that could be prevented. But the mentally ill people I know conducted themselves and their affairs just fine until the day that they snapped. They would have been perfect candidates for legal licenses for weapons prior to that point. But after that point, they would have been able to do plenty of damage with a licensed gun in a bar or on a college campus or in a church. So it's hard for me to accept the rationale that was presented that simply having a license to carry means that one is a stable, law-abiding citizen who poses no danger when they are armed and in various public places. Whether one is certifiably mentally ill or not, just the amount of anger that so many everyday people carry right below the surface is enough to turn someone from seemingly sane and decent into temporarily senseless in a flash. So knowing these things, is it rational to allow guns in bars? I'm sure that many of you have voted in favor of increasingly stronger DUI laws. I assume you do this because you believe that it is not safe for people to mix alcohol with the operation of potentially deadly machinery. DUI laws are made on the basis of potential for harm. And thank God everyone does not fulfill that potential. It is a fact that alcohol, even in a small amount, alters one's sensibilities. And we all know that the intake of too much alcohol can render all sense of sane and rational judgment missing. So can you all really look me in the face and say with firm conviction that mixing alcohol and guns in public places does not create a potential for harm at least of the same magnitude as mixing alcohol with driving? The provisions that I highlight are especially disturbing to me in light of the stand your ground law that exists in Georgia, which essentially gives an individual legal cover to shoot and kill someone whom they simply perceive to be a threat. Throw that into the middle of a bar brawl and see what you come out with. The very idea is absurd. I don't accept the exclusion provision in this bill either, because by design it creates a confrontation with someone who has a weapon. Finally, as a Christian, I choose not to live my life on the basis of fear. And I am deeply offended by the idea that I could have to incorporate into my faith practices the concept of dealing with individuals carrying guns in sacred public places. I am convinced that dealing with the ills of society from a starting place of fear and passing laws such as this one that serve to create an ever-intensifying atmosphere of fear of each other is fundamentally flawed and is a recipe for more and more senseless acts of violence, and the cycle will continue. Somewhere it must stop, and rejecting this bill would be an admirable start. Thank you.
Thank you, Mr. Chairman. Thank you, members of the House Public Safety and Homeland Security Committee. My name is Michael Bishop. This is my wife, Jerry. We're from Harris County. I'm an Air Force veteran, and we have lived in Pine Mountain for many, many years now. We raised 2 children in this nurturing community, a son, Christopher James, known to everyone as Jamie, born November 9, 1971 at the United States Air Force Academy Hospital outside Colorado Springs, Colorado, where I served as a commissioned officer at the USAF Academy School, and a daughter, Stephanie, born August 15, 1973, in Athens, Georgia, while I was teaching at the University of Georgia. Jerry, at that time, was a stay-at-home mother caring for our 2 children. Jerry's a graduate of Auburn University. She later attended Columbus College in Columbus, Georgia, earned a graduate degree in counseling, and retired from the Troup County educational system with many years of service as an elementary school counselor. Both our children, Jamie and Stephanie, attended and graduated from the University of Georgia. On Monday, April 16, 2007, Jamie was teaching a German class in Norris Hall at Virginia Tech in Blacksburg, Virginia. A deranged student came into that building, chained its doors shut from the inside, and with at least 2 firearms and high-capacity clips, shot as many persons as he could, including our son, 4 other instructors, and 25 students. He slayed each one of those persons, while wounding and traumatizing many more, after having already slain 2 other students in West Amber dormitory earlier that same morning. Guns save lives, read the buttons of many here today promoting gun legislation that would make guns in our society more ubiquitous and inescapable than they already are. Our hard-earned knowledge, however, is that guns take lives, and the more powerful and sophisticated they are, the more lives they can and do take. We reject the notion that consenting to guns in schools for persons with a concealed carry permit would better prevent the sort of senseless violence that took 32 lives at Virginia Tech than would expanded background checks, better mental health services, and advanced safety precautions on campuses, some of which have been put into effect since 2007. I might say that we might consider closing the so-called gun show loophole, too, before any of these things should even be considered. I could say a great deal more on this subject to substantiate our position on this issue, including the fact that Jerry and I have worked in education in this state almost our entire lives. And the only reason we're here today rather than last year or the year before is that we couldn't come. We worked. We're retired, and so this year we came. And that very few in our experience in this setting support the idea of concealed carry on campus, even for persons over 21, because students, whether teens or in their 20s, are more prone to drug experimentation, drinking, and also suicide than the general population. And because our campuses, but for the high-profile anomalies like the shootings at Virginia Tech and Newtown, Connecticut, which some people don't even believe occurred, are among the safest places in this nation. I might mention right here that the leadership of the academic communities representing the colleges and universities throughout Georgia are adamantly opposed to this legislation. And would you not agree, I would ask you to consider this, that it is irresponsible to override the authority this body has given to colleges and universities. Who knows better how they operate and what works than these very officials? I'm going to wrap up here. The question then becomes, given that the majority of citizens in the state of Georgia are for background checks, are for, I'm sorry, I'm emotionally involved here, I'll confess that, but I would say to you, as our elected officials, are you going to answer to the majority of your constituents or to a vocal extremist minority more concerned about its personal safety than public safety, and yoked apparently to the fantasy that in any mass shooting one of their number will step up and save the day, a la Bruce Willis in yet another Die Hard sequel? So our question of you today, considering HB 875, is that very question. To whom are you ultimately going to be accountable? Those favoring common sense gun laws, or those who favor the virtually unfettered proliferation of guns because of fear and paranoia? Nothing that we do will make us completely safe from all the accidents and vicissitudes of a fully lived life, but allowing guns to proliferate, as HB 875 would, does nothing to address the larger issues of gun violence in our society. Nothing. And I ask you to please do all in your power to modify, amend, or kill this misconceived piece of legislation. Thank you.
I just have one statement. I appreciate those of you who have been listening throughout all this. I hope this never happens to you. It's the worst thing that can happen to a parent. The 7 years that we've been trying to make it every single day, and being able to do this today makes us stronger. Thank you.
Banks Weiss.
I spoke with you yesterday, so I don't need to speak again if you feel like
Very good. Thank you, Mr. Weiss. Paul Smith. Mr. Smith, if you would, come forward.
Good afternoon. My name is Paul Smith, and I am the Executive Director of Citizen Impact. We're a faith-based nonprofit organization here in Georgia, and we represent several hundred churches across the state of Georgia. And although we respect those with a different viewpoint, a different opinion, we very simply just want to say that we support churches having the option and to decide for themselves on this very important issue. So we support the legislation and support churches being treated as property owners that can decide for themselves whether to allow guns on their property. Thank you.
Any questions from any of the committee members? Reverend, we appreciate it. Thank you so much. Elizabeth Finch.
Mr. Chairman and distinguished committee, I come before you today first and foremost as a woman. I am also an NRA certified instructor, a leader of a 40-member women's shooting chapter, and a supporter of the right and responsibility to defend oneself. I have read this bill in its entirety. This is the best bill concerning gun and private property rights put forth in years, and I'm strongly in favor of it. As someone who is very active in my own church as a Stephen minister, a Sunday school teacher, and a choir member, I often find myself there in the evenings and often walking back to my car, located in one of the handful of parking lots scattered about in downtown Marietta in the dark. Current law prevents me from legally being able to defend myself properly in this situation should the need arise. I take great issue with this for two reasons. One, churches are private property and should be treated as such. No government should be able to grant certain private property rights to one private entity, yet deny the same to another. Secondly, it is my responsibility, and ultimately mine alone, to protect myself. Our police are a wonderful resource, but criminals are not generally known to wait for the police to arrive before committing heinous and unlawful acts. For most victims, the police are there in time for the crime to be reported, but not there in time to prevent it from being committed. I shouldn't be denied by law the right to equip myself for my own proactive protection, whether it's at the grocery store, my house, or a place of worship. Victims are not allowed the opportunity to know when or where they may be victimized. Being one of millions of women who have been victimized at some point in their lives, I've had the unfortunate need to defend my life and my safety. In 1999, I found myself being chased by my ex-husband with an asp baton like many police carry. There was no help in sight and no one to depend upon to save me but myself. I felt 100% certain that my life was in jeopardy at that moment. Thinking quickly, I drew my carry gun at that time from my purse and ordered him to not take another step toward me. That day, I was able to defend myself and deter him from the harm he intended to inflict upon me without firing a single shot. Had I not been properly equipped, I feel very confident in saying that I would not be alive today. As a woman, it's important to me to feel safe, secure, and equipped with the ability to defend myself. As a citizen and a Second Amendment supporter, freedom, liberty, and rights are very dear to my heart. The more limitations there are on where I am permitted to be lawfully armed, the less safe, secure, and equipped I am, and the more my liberty and rights are infringed upon. As a believer in liberty and the Constitution, I'd like to further point out that current and further restrictions upon where carry is permitted by law is, at its core, rooted in distrust of the lawful citizenry, and as such is not in accordance with a free society rooted in liberty. I implore you, as both a woman and a citizen, to support and favor this bill. Thank you for your consideration.
Thank you, Ms. Finch. Any questions from any of the committee members? Roy McLean.
Representative Powell, committee members, thank you for the opportunity to address you today. I stand here before you in support of HB 875. My name is Roy McLean, and I hold an undergraduate degree in religion from St. Leo University, cum laude, with a minor in criminal justice, and I work in issues concerning risk-based security every day. I've spent 24 years in the United States Air Force, the first half active duty and the second half in the reserves, and I currently have more than 36 years of federal service. I know something about how government works and the areas that government should not be involved. I can definitively declare that government should not be involved with decisions that congregations make concerning their worship and private property. In this conversation, we've heard from a number of people claiming to represent one group or another. It's clear that some of them don't seem to have even read or read with much comprehension what HB 875 will or will not do. It will restore to a congregation the rightful owner of such decisions, what they choose to do on their own property. It removes from government interference in private property matters. It will not require congregations to do anything that they aren't currently doing or don't want to do. Let me read that again. It will not require congregations to do anything that they aren't currently doing or don't want to do. Would a Christian congregation or other group of faith-based people stand for government telling them how that they may or may not participate in sacraments of their sacred rituals? Would a Christian congregation stand for government defining the method of serving communion? How about requiring hairnets, food handlers' gloves, and mouth and nose coverings for communion? Would a Christian congregation stand for government involvement in other choice of an acceptable version of which Bible that they're going to read from, pre-1611 King James, Oxford edition, or the NIV? Would a Christian congregation stand for government controlling how they feed the hungry? See communion above. Think food preparation permits and government inspections. A case could be made that each of these things could or even should be regulated for the common good. You've heard a lot of that today and yesterday. I say let the congregation choose what they believe to do, their right course of action, so that it is with protection of persons within that community of believers. Simply stated, HB 875 takes excessive government intervention out of what would otherwise be a simple property rights issue. We've all heard the story of the sheep, the sheepdog, and the wolf story. And the Lord knows that I'm a man of prayer, but the Lord gave us a brain to use to come in out of the rain and to stay away from unnecessary danger. There are wolves and predators in our world today. This much we all agree on. Please don't let political agendas hide behind the government on this issue when they would espouse the exact opposite of any other intrusion into their worship or property rights. I urge you to vote in the affirmative and to send HB 875 to the floor for a full and extensive hearing. Thank you for your time. Any questions?
Thank you, Mr. McLean. We do have one. Ms. Waits.
Thank you, sir.
Yes, ma'am.
Thank you so much for your comments. I had a question for you. We've had several examples, specifically recently in the Rockdale Conyers area, where an individual came into a church
Yes, ma'am.
and displayed violent activity. Can you offer any examples where a parishioner would need to have access to a weapon in a place of worship?
Oh, there's a case in Colorado Springs where a parishioner happened to be in the parking lot, saw a shooting taking place, intervened, and stopped the event there. There are others. I don't have them at my fingertips.
But not in Georgia.
I don't have one in Georgia.
Okay. Would you not agree that this bill also takes away control of local authorities to govern on the issues of gun access? Meaning we have more government control versus local control. Would you not think that this bill usurps the local control?
Oh, no. This bill gives local control back to the churches. It lets them do what they choose to do in their private property.
Thank you.
Anyone else? Thank you.
Any other questions? Thank you, Reverend. We appreciate it. Don Edwards.
Thank you so much, ladies and gentlemen of the committee. I appreciate the opportunity to speak. My name is Don Edwards. I retired from the U.S. Army after more than 20 years and then served another 20 years civil service. But it's not me that I'm here to speak for. I'd like to say something for the people that can't be here to speak today, those that have given their lives in defense of this country and have sworn the same oath that many of you or all of you here have sworn to preserve and defend the Constitution of the United States against all enemies, foreign and domestic. Our biggest enemies against the Constitution right now are domestic enemies who are trying to destroy parts of the Constitution. The oath is a lifelong obligation, and doesn't have an expiration date. Those men, I dare say that everybody in this room either served in the military or has a family member who served. Many of them died or were mortally wounded, came home and died or suffered the consequences of their wounds. The oath they take doesn't say to defend the country. It's an oath to preserve and defend the Constitution. And we take that very seriously. And as I said, it doesn't have an expiration date. It's a lifelong obligation. Much of that Constitution, much of that oath, ironically, doesn't apply to the military while they're in. Anybody who served, especially in a subordinate position, knows that they know what be at ease means. You know, shut up and don't talk anymore. And you can try to work your way up the chain of command, but you can be denied. The Second Amendment would have saved lives at Fort Hood. Prior to President Clinton, soldiers were able to arm themselves in those settings. Senior officers and NCOs frequently armed themselves during the duty day. And the Fourth Amendment, another one, unreasonable search and seizure. A commander walks into a soldier's room and can bust open the locker and search at any time of the day or night. But not only that, he can go off the base and go downtown to an apartment where dependents are living, and under the same rights of a commander, because they're drawing a quarters allowance and a housing allowance and a food allowance, has the right to go into the home and search without a warrant. So those are examples of how the Constitution doesn't apply. But that service member took the same oath that everybody here took to defend the Constitution. I take special issue with what a lot of us folks call the special people in Georgia laws. If you looked at OCGA 1611-130, there's a list of those that are exempt from any of the restrictions that we're talking about today. They carry in churches, they carry in your schools, they carry in college classrooms, they carry in bars, and they carry in churches. They're everywhere. And they're under no restrictions, yet they don't even have a license. Many of them don't have licenses to carry because they're exempt from the need for a license. They can carry in virtually any place that a law enforcement officer can carry. Military, active duty military. So it just goes on and on. We here, the citizens who are fighting for our rights, we believe that shall not be infringed means just that. Yet we are under a lot of infringements to defend ourselves, and those it relegates us to a lower class when you say that these special people, the coroners, the clerk of the Superior Court, the military, retired law enforcement, all these people are entitled to rights to protect themselves that we aren't. Well, why? What makes their lives more valuable than mine or anybody else's in this room? We're the ones paying the tax for the license. They're not paying a dime, just by virtue of the fact that they were elected to their position as a judge, or they happen to be a prosecuting attorney, or any number of those people. You need to look at the law under 130, all the people that are exempt, and what makes their lives more worthy of protection than anybody else. We're a nation of laws. I mean, there are 20,000 laws in this country, and they all restrict the rights of law-abiding citizens. Not one has ever kept an evil person from doing a bad thing. Not one. Think about it. And I've made this promise in the public media, on TV, in social blogs and everything else. I've said, if anybody can construct a law that will keep an evil person from doing an evil thing by any means, I mean, they can stick somebody with a pencil or a knife or anything, I'd be glad to take all my guns here on the Capitol steps and grind them up into very fine powder. And I'll do it in front of CNN or anybody else. It's just not possible to create a law that legislates morality. And it's ridiculous that we're thinking that we can do that. We shouldn't be treated as a lower class of people. We ought to have the same rights of those special people that are exempt under 1611-130, or somebody needs to look away to do away with that list, because I think they've become part of our supporters. Thank you.
Thank you, Mr. Chairman and the committee, and for this opportunity today. My name is Mike Griffin. I am pastor of Liberty Baptist Church in Hartwell, Georgia. I had the opportunity to pastor this year and make 30 years. Also, I am public affairs representative for the Georgia Baptist Convention. We represent 1.3 million Georgia Baptists, over 3,600 churches in our state. And as Georgia Baptist churches, we believe in a long-cherished belief in the autonomy of the local church, and that means the local church having the right to determine its government, its polity, its policies. We talk about Southern Baptist and Independent Baptist. Well, there's nothing more independent than any Baptist anywhere. They won't let anybody tell them what to do, and they don't want even the Southern Baptist Convention telling them what to do. So we believe in the autonomy of the local church, and I'm not here to speak on every nuance of this bill. I know there's a lot of things in this bill. But when it comes to the opportunity for a local church to be able to decide for itself something that we believe is a constitutional right already, we believe that the state should give us that opportunity. Therefore, we believe that Georgia churches should have a right to do what they want when it comes to being able to choose whether or not to have weapons on their property. So I'd encourage you, if for that reason alone, to vote in favor of this bill. Thank you for this time.
Thank you, Reverend. Questions? We have two. Ms. Waits.
Thank you, sir. I'm just curious, can you offer one example in the state of Georgia where parishioners would need to have access to a weapon to protect themselves in a place of worship?
I don't have to have one in the state of Georgia. Okay. We've seen it across the country. In Texas, we had a pastor that used to be at First Baptist in Elberton, in the same association I was in, who was over in Texas, had a situation where I think there was a youth event, and a man came in, pulled out a weapon, and started shooting up everybody. Mm-hmm. I mean, that's just one example, but we don't have to have an example mm-hmm. to defend our constitutional rights. Mm-hmm. If our Constitution says we ought to have that right, mm-hmm. we've got it. And mm-hmm. so, you know, that's just a part of the whole mm-hmm. situation. But there are examples where we're seeing this, and we believe, I mean, I say we, I can't speak, be careful, I don't want to go beyond my statement on Georgia Baptist, I want to get my own personal opinion. I could speak to you as a pastor myself. You know, it's not the absence of guns that make us safer, it's guns that are by law-abiding citizens that bring about the protection, and so we don't have anything to fear from our Second Amendment rights.
As a man of faith, I take your opinion very highly, and my question is this. When you look at the Colorado movie theater shooting as well as the Virginia Tech, the parents are sitting before you, as well as Newtown, you mentioned that more guns would make us safer. You also stated that it was your belief that you should have these rights to choose. My question to you is this. When you look at this incident that happened in Fort Hood, Texas, as well as the D.C. sniper incident in D.C., these were former military officials that we assume were mentally stable. You believe that more guns make us safer. In those three incidents that I just referenced, is it your belief that had we had more guns, that 32 people would not have lost their lives at Virginia Tech? Do you believe that?
If there were other individuals who had the moral ability and the knowledge of what was going on, were mentally capable, they could have removed the threat. And, you know, really, it's a sanctity of human life issue as far as I'm concerned. And the Second Amendment right ends up protecting all life, and so that's a part of it. So I think it's also a sanctity of human life issue, although I'm not here to speak for Georgia Right to Life. But it's a protection of innocent human life is paramount. It's the most important protection that we can have in our country. If we don't have life, we don't have liberty. If we don't have liberty, we don't have property rights. So that's very important we protect. And I think among law-abiding citizens, as qualified in this legislation, no one would have any reason to fear having more people like that around you.
Mr. Hightower.
Start off with one, but now I have two. My first will go to answer your question. I firmly believe that if the right person is there, then more guns would have helped. Because in those situations, I can assure you, if my family would have been there watching this movie, I'd have been up and I'd have put a bullet between the guy's eyes, and we'd have saved a few lives. Hands down. If he's sitting there trying to threaten my family and he's killing other people, we'd have put an end to the threat. People may say, you know, that's bad, that's a bad thing, but if my family's there, if the right person's there, I'm going to put an end to that threat. That's it. And I have a right to defend myself and my family. So in your situation, are more guns make it safer? Yes, if they're in the right hands, which we're trying to talk about law-abiding citizens who have done the right thing here. So if it's the right person, yes, it can definitely help. But now that you just made me think about that when you're talking about this. To you, we've heard a lot about a recent poll that was done by the AJC, and they, according to that poll, I believe their question was worded, if I'm getting it right, their poll stated Georgia law prohibits guns on school property and nuclear plants at bars and governing buildings, mental hospitals, and in churches, temples, and mosques. Some Georgians want to loosen gun restrictions while others want to maintain or tighten gun restrictions. How about you? Do you favor or oppose allowing guns in churches? Now, my wife is a school teacher. She teaches statistics. Now, when I read that, it's kind of leading, in my opinion. Would you not agree that sometimes polls can dictate where the outcome is going to be?
Well, when you read that statement, it makes it sound like you're, going to frisk people down, and if they don't have a gun, you're going to give them one. That's not what we're talking about here. You're not trying to say we just want everybody just, bring as many guns as you can, bring them all with you. You're saying in this bill, if you have a permit, you have had background checks, then if that facility says that's okay, you can. And again, the church issue here, we're not saying we want everybody to bring as many weapons as we can. We're saying under these conditions, if the church says it's okay, then yes, if you meet this criteria. So it's not just like there needs to be some qualifying on those types of polls. I know on my Facebook page, I just threw that out there yesterday. I don't think I had a single person say that they didn't agree that a church ought to have the right to choose. We're not saying that it's going to be demanded that you have to bring guns in order to come to church. We said that you would have an opportunity for the congregation to choose if it wants to. So that's the issue. Should the church, as a property rights issue, be able to say we do or do not want weapons on our property?
And I think you're hitting the nail right on the head with me, and we've rehashed this a lot in these hearings in the past, but it wouldn't surprise you that type of question would lead people to probably say no in that poll. But there was another poll conducted, and I have it here. This was done May 13th, 2013. It was a statewide poll that was conducted, and the question is a little bit, in my opinion, a little bit more proper to what we're dealing with. Because we've heard so much here lately about how that poll came out, and there's so many churches against this and people against this. Why are we doing this? But when you read the question or phrase the question a little bit more appropriately, in my opinion, you get a more exact answer. This is how this poll had put this. If churches and private property owners of bars decide to allow citizens to carry concealed guns on their property for self-defense, should the state government overrule the owners overrule the owners and prohibit citizens from carrying a gun for self-defense on that property anyway? And when the poll was done that way, and you relate it more towards a private property right, it's not surprising that the totals there, you have well over 50% of the people who are saying the government should stay out of private property rights. And I guess my issue is you keep hearing people bring up these different polls, but for every one you can have another say something different. Depends on how the question is worded. But for what we're talking about a private property right. So
Right.
to properly get the right answer here, you have to be honest with your people that you're actually having a poll on, and let them know this is dealing not just with guns in churches. It's dealing with a private property right that the state, should never have been in the business of delegating those rights anyway.
Right, and what I was using the term Second Amendment rights was very important, but those rights end where property rights begin. So at that moment, the property right would trump that, and you would say, no, we're not going to have this. So if you're coming over to my home and I say I don't want any guns in my house, then I should be able to say I don't want any guns in my house. So I don't think we have any. I think liberty is not anything we need to fear in that area.
Yeah. But one last thing, because I heard this yesterday, and I'll get off on this one, but I also heard that there was someone said, oh, well, you could, churches are going to have to put signs up now, but they will not. This does not make a church do anything that they're not doing now. As a private property owner, I don't have to put a sign up on my property saying that I'm not going to allow guns, nor will churches have to do that. This is a decision that the church can make. They can choose to enforce that however they choose. If they don't want firearms or weapons or guns on their premises, they can choose to display or not display or convey that message however they see fit. But this does nothing to require them to put anything up, correct?
I'm not sure if there's any declaration there specifically regarding a sign.
There's not.
I'd have to appeal that to the author, but I didn't see anything that said that myself.
Okay. Thank you.
Thank you, Mr. Hightower. If you'll bear with us, you're a popular guy, Mike.
Only you would know, Mr. Chairman.
Mr. Holcomb. Ms. Waits? Was that you, Ms. Frazier? Excuse me, Ms. Frazier.
Thank you, Mr. Chairman. I just have one question for just verification. Now, you say you represent the First Baptist Church.
No. I am the pastor of Liberty Baptist Church in Hartwell, Georgia.
And what is your other title?
I represent the Georgia Baptist Convention. I'm their public affairs representative, their lobbyist here at the Capitol.
So so you got permission to represent, you said over 36,000 churches?
3,600 churches, 1.3 million members in our denomination. That's the representation of our convention.
And all of these churches are in favor of this bill?
I am representing them as I was given the responsibility by the convention of the executive director, yes. So we do speak on their behalf.
I just needed clarification. I just
Well,
want to
sure,
make sure.
I wouldn't be here if they didn't want me here.
Would you like to speak again?
I just had a question for Representative Hightower. Sure. The concealed carry permit, he indicated that for individuals who have the concealed carry permit. When I acquired this a few years ago, I was not required to know how to load the weapon, unload the weapon, or shoot the weapon. So do you think it's safe for individuals who can't unload, load a weapon, or shoot a weapon to be able to take a weapon wherever they want, even with this particular permit? Do you think that's okay?
Representative, we have someone that's testifying. I'm going to let you two hash it out.
Thank you.
Thank you, Reverend.
Thank you, Mr. Chairman.
Thank you for being here today. LaDonna Lowe.
Thank you, ladies and gentlemen. I appreciate your time. I didn't come today with a prepared speech. I just came to show my presence in support of this bill and my Second Amendment right to carry a gun if I so choose. I will tell you that I am a licensed Georgia carrier. I am a certified NRA instructor. I am a woman's shooting group leader. I have multiple certifications from the NRA, and I am quite a good shot. And so I do feel like I am qualified to speak about guns. And I do want to say my heart breaks for you. I do know how you feel. I lost a child also. If you haven't walked in those shoes, you can't speak to how that is. That is truly the worst thing that a parent can ever go through. We're not supposed to bury our children, but I digress. My child was killed with a different kind of weapon. It wasn't a gun. It was an automobile. It wasn't by a drunk driver. It was by a mom dropping her kids off at school, and my child was killed. So there are many things in our world that are dangerous. They can take a life. And I think we have to take that into consideration when we are looking at guns. A gun is just an inanimate object. It doesn't do anything by itself. And you can be trained. And I think it is every person's responsibility to be trained. I carry a gun every day, and it's not because I'm scared. It's not because I'm paranoid. It's because I am prepared. I put my seatbelt on every time I get in my car because I don't drive out of my garage thinking, oh, I'm going to have an accident. But I am preparing in the case that I do have an accident. I'm prepared. I strap on my gun every day, not going out thinking, oh, I'm going to have to shoot someone, or someone's going to attack me, someone's going to rob me, someone's going to carjack me. But I am prepared in case of that. When I go to church, I can speak to a situation that happened. It wasn't in the state of Georgia, but it was at another church when we lived out of state. And there was a gentleman that came in, and his intent was not to worship. Luckily, we had 2 police officers that attended church, and they were sitting at the back. And when he came in, they were able to take care of him. So it does happen, and I believe it is our responsibility, as Ms. Finch stated, that we be our own defender. I have lots and lots of friends that are police officers, and I admire and respect them, but I can't guarantee that they're going to be there when I need them. So it's my responsibility as a human, as an adult, as a woman, to be able to defend myself. So I ask you to consider, as humans, as adults, as men and women, you have pledged an oath to our Constitution to please take into consideration that we have already been given this right with our Constitution. Please pass this bill. Thank you.
Chairman Powell and committee members, I'd like to thank you for the chance to address this body. I've had the bug that's been going around, so I promise not to cough on you, but my voice is weak. My name is Carolyn Meadows. I'm an NRA, National Rifle Association member of the Board of Directors. And I do speak on behalf of the NRA. And I would like to communicate to you from them our strong support of House Bill 875, sponsored by Representative Rick Jaspers. HB 575 is the most comprehensive legislation introduced in recent Georgia history, and House Bill 875 seeks to make beneficial changes to our current law. It's been a long day, and I too believe in brevity, Mr. Chairman. So I would like to just make 4 short points. The first one, the components of this bill, such as opening up more locations across the state where law-abiding citizens will have the ability to protect themselves against violent attackers, are of paramount importance to enhancing the personal safety of Georgia residents. And the second one, equalizing the playing field for individuals residing in public housing and ensuring that their Second Amendment rights are protected regardless of their living situation. And the third, remove the unnecessary burden of fingerprinting a firearms owner upon the renewal of a license that has already been approved and vetted through a federal background check. Protecting the privacy, number 4, protecting the privacy of weapons carry license holders by prohibiting the creation of any database of law-abiding citizens' personal information. We've had enough of that. These positive advancements, along with others listed in this bill, make this piece of legislation critical and critically important to protecting and advancing the rights of hunters, shooters, and gun owners throughout Georgia. The benefits of this positive legislation are wholeheartedly supported by the National Rifle Association, and I would ask that all of you support this bill, House Bill 875. Thank you, sir, for your time, ladies.
Thank you, Ms. Meadows. Would you stand for a question or two?
I've tried to.
Well, we have Ms. Waits.
Thank you so much for being here today.
Thank you.
Would you not agree that bars are a place where individuals consume excessive amounts of alcohol?
I don't frequent them, so I'm not real sure of that, but I would trust the fact that people that have armed themselves would in fact be responsible.
Would you not agree that guns and alcohol does not mix?
Well, I don't know. The Lord's Supper, they had wine, so
out of respect for the 32 lives that were lost at Virginia Tech, according to new research, The American Academy of Pediatrics, they've treated over 7,300 children that were hospitalized due to gun wounds. And they've offered a suggestion that our community would be much safer without guns. Would you not agree with that statement?
No, I would not. My son is a board certified pediatrician in allergies, and I need his help right now with his allergy. For whatever reasons that group of people have chosen to invade, they now, some of them, not my son, but they are asking people, even if when they treat their children, do you have a gun in your home? Mm-hmm. That is wrong. That's wrong.
Final question, Mr. Chairman. May I have one more?
One more, please.
Studies have revealed that the frontal lobe of the brain, which controls the higher thoughts for urges, do not fully mature until 25 to 30. Thus, would you not agree that it would be reckless to place guns in the hands of children? And also, would it be reckless and dangerous on college campuses? Would you support that statement?
Well, it has nothing to do with this bill, with all due respect. You have to be 21 to carry a gun. But in the part where 18-year-olds, yes, I would support it.
So you would agree?
As far as the frontal lobe goes, I have no clue.
But you would agree that the brain does not mature until 25 to 30?
No, I wouldn't, not unless I had more knowledge. So, and to you, dear people, I would say, my heart bleeds for you, a precious member of my prayer group who was killed by someone, and if she could have been armed, I feel like she would have been here. So, thank you.
Ms. Mathers, thank you for taking time to come today. We have a couple of representatives, and I think they want to address specific parts of the technical language. Mr. Rushi Patel with GMA and Mr. Todd Edwards with ACCG.
Thank you, Mr. Chairman. And you are correct, Rushi Patel with the Georgia Municipal Association. I do want to address some specific language, and the language I'm looking at is on page 21, line 724. And this is new language to the bill this year. I actually have some suggested language here. I don't know if...
Line what?
724. This language on page 21, line 724, allows any person in the state to bring a civil action against any city or county for any perceived violations of the state preemption on local governments with firearms regulations. Now, I want to be very clear. This right of action, the person does not actually have to have a valid claim, does not actually have to present any valid violations. But the city will still have to pay to defend itself, which means taxpayer money will go to defend against frivolous claims. And I can give you an example that may pop up. The city of Kennesaw has enacted an ordinance many years ago that mandates heads of households to carry firearms. This has seemed to work for the city of Kennesaw. But if an average citizen decides the city of Kennesaw is not doing enough to ensure the heads of households are carrying firearms, they might file a claim. Obviously, that claim would be frivolous, but the city would still have to defend itself. Additionally, this language states that the person that filed a claim is entitled to attorney's fees and expenses of litigation. The language does not grant the same thing to the cities and counties. Even if the cities and counties were granted attorney's fees and expenses of litigation, if that person was indigent, the city and county would never see any money out of it. They would have to fight a frivolous claim and not get anything back in the end. So we have a suggestion that we understand that if there's violations from the city or county on the state preemption of firearms regulations, that the legislature wants there to be a recourse. In other areas of the law, that recourse is by filing a complaint with the Attorney General's office and the Attorney General bringing a civil action against the city or county. We think that's a reasonable compromise. And that's the one section of the bill I wanted to address, and I'll turn it over to Mr. Edwards.
Thank you, Mr. Chairman, members of the committee. I'm Todd Edwards. I'm with the Association of County Commissioners of Georgia. There's been a lot of conversation about home rule, local control. Stood before you last year, and I urged that the decision as to whether or not local government buildings, the prohibition, would be lifted. I'm not either for or against that, but I would ask that you leave that up to the local decision-making authority, be it the county or the city. Obviously, I wasn't too successful with that argument last year, but I did want to go on record once again, Mr. Chairman, as wanting that to be at the decision to be made at the local level. Some of our county commissioners, quite frankly, would like that. Some of them would not, but again, that would be made at the local level. I think the language in here, the decision is made to go forward with allowing them into government buildings. Regarding the security monitoring ingress, the language in here states that it would be during business hours of the building when it was open. My question would be, and perhaps we could work on some clarity, is if 4 days out of the week, if there wasn't a contentious zoning, planning meeting, or anything else, there was no security, thus individuals were allowed to carry a concealed weapon. But 1 day out of the week, they do have a zoning hearing. It is expected to be heated. They have the security. Are they allowed to restrict access, even though the law says, and they clearly didn't have it, during all days of the week during the business hours? I mean, that's just something I'd like to hopefully work with y'all. I'm not sure what the intent, but if it's at any point they put up security, I'd like for them to be able to monitor or restrict weapons in there. Another thing is we're hearing from some of our judges regarding the definition revisions to the word courthouse, which used to be any building that had housed courtroom proceedings. The new proposed definition strikes out building and portion of building. So what we have in a lot of areas are buildings where folks would be able to carry guns unless you had security monitor, and then they could cross over the courthouse. There's a lot of confusion. After the Terry Nichols case some years ago, this General Assembly acted and mandated that each county, each sheriff, and the counties enact courthouse security plans. There's a lot of concerns that at the same time we're trying to accomplish that mandate, that this may cause confusion or in fact impede our ability to follow state law in that regard, and we'd like to get with you and discuss that later. I know there's steps along the way, but I did want to at least go on record with the concerns of ACCG at this first initial hearing. And Mr. Chairman, I thank you for the privilege of being able to do so.
And I thank my two friends from local government for being here and as always being so direct and courteous.
And of course, I'm happy to answer any questions, Mr. Chairman.
Now, do we have any questions of our gentlemen from ACCG and GMA? Nothing was. Yes, Ms. Waits.
But for the individuals who were not here during the slaying at the Fulton County Courthouse, can you give us a 1-minute description of what happened for the individuals who don't live in Metro Atlanta to the judge by Brian Nichols?
We were in the Capitol that day. There was quite a bit of commotion outside, and we later learned that I believe, and I don't have all the facts, it was a detainee, court proceeding, broke loose, stole a gun, shot a deputy, a judge, and went and there might have been someone else in the courthouse, went out and shot at another individual working on a house roof. That's about all I remember of the case. It did create quite a stir, got a lot of attention, and thus we are mandated to have court security plans, for which we paid a pretty penny. Taxpayers
any more
have
questions?
paid a penny.
Thank you. Any other questions from any of the committee members? Thank you, gentlemen.
Yes, sir.
Let's see. And I believe we have one last speaker, Mr. John Monroe.
Thank you, Mr. Chairman, members of the committee. I apologize in advance for my voice. I've got a bit of laryngitis. John Monroe with GeorgiaCarry.org. I'm the vice president. GeorgiaCarry.org has about 8,000 members in Georgia. It's a grassroots organization supporting the rights of its members and other Georgians to keep and bear arms. Georgia Carry strongly supports this bill, so I won't go through any criticisms of it or even go through the points of it. But one thing I did want to do is address some of the criticisms that were raised either yesterday or today. And one thing Representative Hightower has already mentioned was the issue of signs. I think there was some thought yesterday that some property owners, such as churches, would have to erect signs if they didn't want to have guns. There's nothing in the bill that would require that. They're free to erect signs now if they want to. If the bill passes, they'll still be free to erect signs. I should mention, though, as a matter of criminal trespass law, putting up a sign saying no guns wouldn't really have any effect. You'd still have to either eject the person or exclude them under the criminal trespass law. Putting up a sign saying you can't come in without a shirt doesn't mean that if you come in without a shirt you've trespassed. It just means somebody's probably going to see you without the shirt and tell you to leave. I also wanted to address Representative Holcomb's question yesterday about pointing a gun or a pistol at another and why that was being stricken. I can't address why it was being stricken, but I can address the crime generally. It's a relatively minor crime, even though it doesn't necessarily sound like it, and that's because we have another crime, aggravated assault, which is charged much more frequently in a situation where somebody does point a gun at another. Although I've seen case law where people have been charged with pointing a gun or pistol at another, I've never had a client who has, and I don't even know of somebody who's had a client that has. I don't know if you've prosecuted any or not when you were a prosecutor, but the thing with pointing a gun or pistol at another is if the other person sees you pointing the gun or pistol at him, he's probably frightened by that, and that constitutes all the elements of aggravated assault, which is a 20-year felony instead of the misdemeanor of pointing a gun or pistol at another. Really, in order to be charged with pointing a gun or pistol at another, either the person has to see you point the gun at him but not be scared, or not see you point the gun at him. And those fact patterns just don't come up. It's pretty rare to see somebody point a gun at somebody else, but the person who is pointed at didn't see it, and this third party reports it and prosecutes it. It just doesn't happen. So as our gun crimes go, it's a pretty minor crime. I wanted to talk a little bit about the churches, since there were several comments on that yesterday that seemed to imply that if the bill passed, churches would be required to allow people to carry guns there, which of course is not the case. What really astounded me yesterday, though, was the number of representatives from churches or faiths that was actually asking the government to step in and interfere with their own operations. In fact, I think one minister said, "We can't manage our own affairs, so please come criminalize it for us." Frankly, I'm astounded that a church couldn't manage its own affairs, but if it can't, it's not the business of government to manage churches. The First Amendment prohibits that. And somewhat ironically but tragically, while this bill was being debated yesterday, there was a church shooting in Lithonia. I think one minister said that Georgia should not be the leader in this area, somewhat implying that if Georgia were to decriminalize carrying guns in churches, that that would make Georgia somewhat of an outlier. In fact, the opposite is true. Georgia is an outlier today. 45 states do not criminalize carrying guns in churches. Georgia is one of the very few that does. Georgia is being the leader in the wrong direction. Now, I think there was a complaint yesterday that there's not a provision in the bill to suspend a license for somebody who was convicted of carrying a gun in an unauthorized location. Well, that's technically true because under current law, you can have your license revoked for carrying a gun in an unauthorized location. There's no need to suspend a license after it's been revoked. There also were multiple complaints about the airport language in the bill. Some people somewhat derisively describing a situation where a person inadvertently carries a gun through security and why that shouldn't be something, and criticizing what the bill would do with that. The people who were making that argument seemed to think that under current law it would be a crime for someone to carry a gun past security in an airport. But that's not true. If you look in the books in Georgia today, if you have a license to carry a gun, there is no crime for carrying a gun past the security in the airport. Not a state crime. I know people get arrested for it all the time, and the Clayton County solicitor may charge you with carrying a gun in an unauthorized location in violation of 1611-127. But there are only 8 locations listed in 1611-127, and none of them is the airport. It's not a crime to carry a gun past security in the airport today, and this bill would criminalize it. And people who apparently didn't like the idea, thank you very much, people who apparently didn't like, who don't like the idea of carrying guns in airports, nevertheless criticize the bill for that. And this bill would actually criminalize what currently is not a crime today. I've heard comments both yesterday and today about the public gathering law. I think, in fact, the former representative who spoke yesterday talked about what's written on the back of a Georgia weapons carry license and how it quotes the public gathering law. And I just wanted to point out to the committee that law was repealed in 2010. It hasn't existed now for 4 years, and it's no longer a crime to carry to a public gathering, and the language she was talking about is no longer printed on licenses. Just briefly on the carrying of guns in schools, I know there are some comments against that. One other thing I'd point out is current language in the law in 1611-127.1 allows school officials to allow anyone to carry a gun in school. Presumably that means I can get permission from a school principal to carry a gun in my child's school just with the stroke of a pen from the principal. And what this bill does is create a separate path whereby the school board can designate people to be carrying guns, allow for training and things like that. It's really a more restrictive path. I guess my point is, if there's not an issue with the way things are being done today, this more restrictive path certainly wouldn't be any more of an issue. One more drink. Then I've heard some talk today about guns and alcohol, carrying guns in bars. It's already legal today to carry guns in restaurants that serve alcohol. That's been the case since 2008. And since 2010, it's been legal for people who are carrying guns in restaurants that serve alcohol to consume alcohol. It remains illegal to discharge a firearm while intoxicated. But under Georgia law, the only difference between a bar and a restaurant that serves alcohol is how much food they sell. Otherwise, they're the same thing. We haven't had any problems that I've heard reported anywhere on people carrying guns in restaurants that serve alcohol, and there's no reason to believe that we would have problems in establishments where they don't sell quite as much food. Now, multiple people have testified that, I guess from a somewhat emotional reaction, that they just want to keep misdemeanor crimes in place that make it a crime to carry a gun in a certain location, apparently under the belief that the existence of the misdemeanor will somehow prevent somebody from committing a serious felony. That's not really a rational belief, because someone intent on committing the serious felony with a gun certainly doesn't care about the misdemeanor they might also be charged with for carrying a gun where it's not authorized. Then a couple comments on the GMAACCG suggestions. If you were to have the Attorney General office be the sole body with a private right of action to enforce the preemption statute, that would mean that the Attorney General would have to prioritize whatever violation there was with other pressing matters the Attorney General has to deal with. A municipality could, if it chose to, thumb its nose at the law and hope the Attorney General just doesn't have the time to deal with it. If you don't think that would happen, I can give you an example. A few years ago, on behalf of GeorgiaCarry.org, I sued several municipalities in Fulton County, all of whom had ordinances banning carrying guns in city parks. It was all one case, GeorgiaCarry.org versus like 8 different municipalities in Fulton County. Within a few weeks of filing and serving the defendants, all of the defendants except one changed their ordinances so that it was no longer a violation to carry a gun in a park. All except one. The city of Atlanta refused to change its ordinance. Filed a motion for summary judgment. We went to court. The Superior Court judge held up an opinion from the Court of Appeals saying the preemption statute says what it means. Why am I not bound by this? Why don't I have to enjoin you from enforcing the ordinance? And the city said, I don't know. We just don't want to change it. So the city of Atlanta made us go through the time, the trouble, and expense of dragging them to court, having multiple hearings, only to put off the inevitable of us getting an injunction against the city of Atlanta. And it costs a lot of money to do things like that. And if municipalities are going to insist on making us do that in order for them to do what this body tells them to do, then they ought to have to pay the expense of doing that. And lastly, the bill doesn't really have anything to do with courthouse security plans. Courthouse security plans by law are confidential. They're not public record. They're not public documents. They can't be examined by a member of the public. I can't go to the sheriff of Fulton County and say, I want to see the Fulton County courthouse security plan. By definition, that means there's no regulation of the public in that document. There can't be something in that document saying, and you can't carry guns in the courthouse, because the sheriff can't enforce something against me in a confidential document. If it's going to be something I can't do, it has to be public. If it's not public, it's not enforceable against me. The things that are in the courthouse security plans, presumably then, are internal operations, what you do if there's an emergency, who goes where, who hides where, who goes out what door, and things like that. But the courthouse security plans are separate from what the public is or is not allowed to do in a courthouse. Those are the comments I had, Mr. Chairman, but I'd be happy to answer any questions.
Thank you, John. Any questions? Ms. Waits, of course.
Thank you. Generally, would you not agree that patrons go to bars exclusively to consume alcohol? Is that reasonable?
No, I don't think that's true.
Okay. Would you be open to a friendly amendment that would require our concealed weapons permit holders to at least know how to load, unload, and shoot a weapon? Is that reasonable?
Ms. Waits, he's not the author of the bill, and he's not on the committee. You are. So he can't accept an amendment. You need to pose that to the committee.
Okay. Thank you, Mr. Chairman. That was the last question.
Any other questions? Do you have any questions? Thank you. Appreciate your time in this issue.
Thank you, Mr. Chairman.
All right, ladies and gentlemen. At this time, we have gone through 2 days of testimony on top of the testimony of last year. If the author might come forward. In the posture that we will be in at this point, I think that the author, has some proposed amendments. Also, we have Representative Battles here. Chairman Battles, do you wish to say just a word or two about your section of this bill, or are you content that it's been thoroughly vetted?
Thank you, Mr. Chairman. Okay. Excuse me while we hook up here. Thank you. I appreciate you allowing me to come and share just the portion that I was involved in last year, and that was the portion that dealt with school safety. You find that on page 17 of the bill. in Section 8. It deals in some degree with carry-on school premises, as well as buses that are used for transporting students. But the portion that I clearly was involved in was those schools that were concerned about not being able to have security individuals in their schools during the day. And from that, we proposed that there would be a designation of those within the school who, through proper training and was willing to serve in that capacity, would be armed and would be considered that security officer or officers within that school. I appreciate the chairman. There has been some modification to that, some shoring up on that, but it is a good bill, and it certainly is a good portion of this bill that I highly recommend and support. One of the things that about this particular piece of legislation that I was involved in is the assurance that was a concern, and that was with training. These individuals that would serve in the schools as security officers would, in fact, and you can go down to line 598, those training of approved personnel's prior authorization, such as personal carry weapons, would be trained, minimum including training in judgment, pistol shooting, marksmanship, and other, and a review of current laws relating to the use of force. And so these are not individuals that would be in the schools that would not be prepared to act on the benefit of protecting those children. The other issue, and it really came about, Mr. Chairman, was based on some of the superintendents within the state of Georgia who did not have the funds to put a security officer. Funds were just not there. So in order for them to do what was necessary, they felt, was to use someone internally, maybe a former law enforcement officer, maybe with prior military experience, that could be willing to serve in this capacity, be trained, would go through all of the requirements of evaluating their stability, and then they would serve in that capacity for those schools at a very minimal cost of what it would cost to put a security officer there. And that was my portion of the bill, and I appreciate you allowing me to Representative Jasper, to allow me to have a piece of this piece of legislation.
Thank you, Mr. Chairman. Do we have any comments or questions from any of the committee members? This chair thanks you for your work on this, since this is a culmination of many different bills that was put forth last year.
Sure.
And then perfected into this year.
Thank you, Mr.
We
Chairman.
thank you very much. To the author, do you have a list of any potential changes that you want to that you would like to see considered?
Yes, sir, Mr. Chairman, I do. Have the committee members. You're on a different LC number. You know, I think we're all on the same one, the same page numbers, line numbers. If you look on line 201, with me. Okay, and here's where we're talking in the bill, you know, about being a non-arrestable fine, but a fine for $100. We neglected to put where those fine dollars should go to. So we'd like to add an amendment upon the Legislative Council's help to make sure I say this right, but at the end of line 201, these fine dollars shall be remitted to the local jurisdiction.
Council, do you have this?
Absolutely.
Now, if I might, for the sake of keeping some order on this, if you would, have you got these numbered?
I have two more.
All right, well, we will call this Amendment 1.
Yes, sir.
Page 6, line 201, to come back to.
I believe the appropriate word is not jurisdiction.
Is that the $5? Is that what we're?
It's 100.
Let's see. Is this you, Mike?
Yes. Thank you, Mr. Chairman.
Representative
Thank you, Mr. Chairman. Representative Jeffs, I'm trying to figure out, when you say local jurisdictions, I'm trying to get some clarity on that, because some of these entities may not. Now, when you say college, what if that's a private campus? How do we transfer public funds, even in the sense of fines? How do we transfer that through a private college, or would it go through a general fund of the county, or would it go through the university, or would it? How would you? Because these are public funds, how would we do that? Could you help me out with that?
If I'm not mistaken, I'll let John Monroe help me with this.
Okay.
I think what he's intending is that the fine would be remitted to the local government jurisdiction, meaning either the city or the county if it's not in a municipal area.
So if somebody carried a gun onto, follow up, Mr. Chairman. If someone carried a gun onto Clayton State University in my county, and they were fined for that, that money would not go to Clayton State University. It would go to the county general fund. Is that what you're?
It would be the general fund. It would be the jurisdiction. The Clayton State or any other college, they don't have a court of their own.
Right.
That would go to the local jurisdiction for where the offense occurred. If it was in a municipality or in a county, it would go into that court if the fine was levied.
Okay, so basically, Mr. Chairman, you're saying in our judiciary there in Clayton County, yes, they would direct those funds to where those funds need to be. So It wouldn't be the responsibility of that entity.
Right. It would go to if it was in the county or in the municipality, whichever.
So in this case, jurisdiction is defined as that county or wherever they lie within those
wherever the offense took place.
Okay.
All right. Have we got that amendment? You got it clarified, because you're going to have to read it again in a few minutes when we vote on it.
Okay.
All right. Second one.
The second one is, if we'll look on line 719. I believe I have a mistake. It should be at line 716. Okay, there's going to be, there's a 1, 2, and a 3. There's a 2 on 712. We'll add a 3, and I'll read it, and then I'll just hand it to Legislative Counsel. It's from the Prosecuting Attorneys Council of Georgia. The District Attorney and the Solicitor General in counties where there is a state court shall regulate and determine the possession, carrying, and transportation of firearms and other weapons by county employees under his or her supervision, as long as the regulations comport with state and federal law. And that follows, if you look in 1, we're talking about making sure that the sheriff, chief of police, and commanding officers of law enforcement agencies regulate and determine the possession and carry of weapons under their order.
Would you like to explain? Would you like to explain why we're doing that?
Because they requested.
Well, because we can't. because they had some concerns that we might have taken out the court officials.
Yes, sir. Thank you.
Yes. Unintended consequences. Representative Glanton. All right. Do we have any questions from any of the committee members on the Second Amendment? All right.
And amendment number 3, look on line 82. Sorry, I have them out of order. That line where it says courthouse means we've crossed out building, underlined portion of a building. We're going to remove in a portion of a building and restore building. So that really goes back to original language. Is that clear? This was council. Thank you.
All right. Would you like to address that?
This is addressing the concern that you heard just from ACCG judges across the state that maybe unintended consequences of how we did that. I'd really like for us to go back and look, not a lot of complaints, but make sure we're doing exactly what we want to. Because we do, you know, original intent of our bill is to let citizens with a license travel in these that are not the court areas of a courthouse.
Right.
And that will accomplish that.
Right.
That is all the amendments I have.
You have 3 amendments.
Yes.
All right. Now, to the members of the committee. I'm sure that some of y'all have probably pondered on this. Is there any amendments to be offered by the committee members? Are y'all sufficiently beat down? I would like to offer an amendment on line 612. This is a mandatory method of securing weapons if school boards do allow or decide to participate in a school security system. On line 612, I would like to strike in a holster so that will read, shall be, that a weapon, we're referring to a weapon that says, shall be carried on the person and not in a purse, briefcase, bag, or similar. If you remember last year from the discussion and perfecting that bill last year, we had, the committee was adamant that if a school system decides to do such, that a weapon would be kept on the person, not in some auxiliary method that a student or someone might could get to that. Because I was told that to put this in sync with other areas of the law, that holster is not particularly recommended since it's not uniform, since we have a lot of other methods that people carry a weapon on their person. So this basically just would say that they would carry it on their person. So striking the 3 words in a holster, and it would read, shall be carried on the person and not. All right. And that would be number 4. All right. Now, do we have any others? Ms. Waits.
Yes, Mr. Chairman. Line 372, where it takes out that provision of pointing a gun at another.
3.
372. Maybe. Sorry, 370 it is.
All right. And what is your will?
That we leave that provision in the bill.
So your motion would be to strike the strike and return it to its original language.
Yes, sir.
Pointing a gun or a pistol at another in violation of.
Correct. I had some calls today from members of the domestic violence community that were concerned that that particular provision served as a deterrent to abusers. And so they would like to see that provision remain.
We have a motion, and that would be number 5.
I have one last one, sir.
Yes, ma'am. Well, you got it.
I'm not sure where it's appropriate. I would yield to Legislative Counsel. We are wielding a lot of power and responsibility to concealed weapons permit holders. And so my thought would be that maybe this is the appropriate time that we require some basic provisions of safety, meaning that they would know how to load, unload, as well as shoot a weapon. That would be the final amendment.
Have you got that language prepared?
I do not.
While we are asking a few more questions, do you think you could prepare that language?
Yes, sir, I will.
All right, then we'll come back to you. Let's see. Mr. Holcomb?
Yes, sir. I don't have amendments, but I still have questions, if I could ask them.
You know, I think while Ms. Waits is preparing her amendment, this would be a good time for you to ask, as long as you don't try to drag it on out.
I'm not going to drag it out. They're very specific. One is to make sure that I understand the law, and probably Mr. Monroe can help me with this. With respect to the changes for, and I've read the Georgia Carey versus Georgia cases, both the state and then the 11th Circuit case on bringing into houses of worship. Because it's
unfortunately, so have I.
Because it's misdemeanor offense that we're eliminating, one of the amendments I was asked to consider was to have it be opt-in for churches, but that wouldn't work since it would be a crime that we're getting rid of, correct? It's either we have it or we don't.
I think that's right. I don't think you can delegate to the churches whether or not something's a crime.
And the same thing for a bar. So in terms of where we're going is if this is passed, then it will be that it's not allowed, or it's not a misdemeanor rather, but then each place, whether the bar or the church, could, since they are private property owners, determine that they don't want to allow this on their property. Is that fair?
That's true under penalty of criminal trespass.
Okay, thank you. The other thing is, with respect to the question I had yesterday that you addressed today, can you point me to the code section on that? I know what you're saying, but I was just looking up the law, and what is the other section that would be applicable there so that we wouldn't have to delete it?
I'm not sure which issue you're asking about. Are you on the pointing a gun and a pistol?
Yes.
The other one's aggravated assault. It might be 1611. It's in the assault section generally. It might be 1611-46, somewhere in there.
Okay. And the last one is a money question. Line 671. It says that a person convicted of a violation of this code section shall be fined not more than $10 if he or she produces in court his or her weapons carry license. Does that even cover the cost to the court at $10?
As we were just talking, I believe that's as true as is for driver's licenses today.
That's the same fine that we have? Okay.
It probably doesn't cover the cost.
Yeah. Okay. Thanks.
Is that it, Mr. Holcomb?
For now.
Yes.
Thank you.
Ms. Waits, have you got your language ready? All right. If you could you please read that to us?
Yes, sir. In the appropriate place, the Georgia General Assembly shall require all concealed weapons permit holders issued after July, whenever this bill goes into effect, to have basic knowledge of operating a firearm. A, basic knowledge would be loading, unloading, and shooting a firearm. B, all Georgia licensed gun ranges would be authorized to conduct the basic safety training. C, the fee shall be no more than $35.
Is that it?
That is it.
All right. Then if I might ask, Julius is the committee attorney. She's got some glaring holes in there. One is we need to know the effective date, and two, where do we need to place that in this bill? If you could help her with that. Beg your pardon? I'm sorry. Mr. Lunston, is that your light on? I'm sorry. No. To the committee, while we're waiting, is there any questions that any of the committee members would like to pose in the essence of time? Yes, sir.
I'd like to know if those people that are exempt under 1611-130 would also be exempt from the training requirements.
Well, you hold on. We'll get our counsel to look it up for you. Or probably be easier for John Monroe to look it up. Yes, sir.
Mr. Chairman, I have a question as well about the training requirement. Different firearms have different loading procedures. Shotguns are different from pistols and rifles. Which firearm would be specifically used for the training?
Can't answer. I presume that what our colleague is talking about is a training for a concealed weapon permit. And of course, it will have to pass by the majority vote of the committee. Are you leaving? Are you leaving? Oh, we'll fix the vote on this.
Subsection.
All right.
Got it. We're ready.
We're going to wait till you get there. Anybody need to go?
This is not the same thing.
Since the chair is giving a lot of latitude while our committee member is
I'm ready.
getting her stuff ready, we're going to take about a 5-minute restroom break. Representative Jaspers. All right. Has everybody came back from wherever they went? Well, have we lost another one of our members? He comes right here. All right, ladies and gentlemen, the posture, committee members, the posture that we are in is that we have the bill is LC 41080182S. Is that correct? That is correct. Best of my recollection, I see that we have 6 proposed amendments. Does any other member want to bring forth an amendment at this time before we start voting on these? All right, what's the will of this committee? Chair will entertain a motion. Motion? We have a motion to pass. We have a second subsequent motion for amendments. Representative Jaspers, would you like to relay yours, and let's see if we can get some motions on. Let's start with number 1, which would be line 82.
Mr. Chairman, I believe Amendment 1 is on 201.
Yeah, I'm going down from the start of the bill down. Would you like to move number 1 amendment will be line 82?
Okay. What would you like me to do? I'm sorry.
If you would read your amendment one more time, or would you rather or would you rather get counsel to do it?
I'd rather have counsel read it.
Counsel, if you would, amendment 1, which is the one that deals with line 82. Which would then read, courthouse means a building occupied by judicial courts and containing rooms in which the judicial proceedings are held.
Yes, sir.
That is correct. This is number 29. Representative Atwood?
I was going to make the amendment, Mr. Chairman. I hit the
Very good. You are recognized to make
Amendment 1 would be strike portion of building, place, add building, following means A. It would read thusly, courthouse means a building occupied by judicial courts and containing rooms in which judicial proceedings are held.
Very good. We have a motion. Do we have a second?
Second.
I have a motion and a second. Do we have any discussion from any member of the committee on the proposed amendment? If not, all in favor say aye. Aye. Opposed? And that? One no? Very good. Second amendment, line 201. Counsel, if you might read that.
Line 201, before the period at the end, insert the language, such fine shall be remitted to the local jurisdiction where the offense occurred.
Chair recognizes a member to make that motion. Representative Hitchens.
Motion to pass.
We have a motion that that verbiage be incorporated. We have a motion. We have a second. We have a second. Do we have any questions from any committee member? If not, all in favor say aye. Aye. Opposed? No one is opposed. All right. Amendment number 3, line 713. Counsel? I think that was the one that we changed the order on 712 to 2, the numerically 2. I think that's correct.
Yes, sir.
Okay. Inserting at line 716, the new paragraph 3 that reads, the district attorney and the solicitor general in counties where there is a city court shall regulate and determine the possession, carrying, and transportation of firearms and other weapons by county employees under his or her supervision, so long as such regulations support the state and federal law.
Very good. motion? Yes. We have a motion. We have a motion. We have a second. Question. Mr. Hightower.
This is for Lacey Council. When you read that, the way that it's worded there, it seems as though that those individuals would be able to regulate their employees at any time. But I think the purpose of that section would be to regulate them during their time of employment, during their working hours. You see what I'm saying? The way it reads, it seems as though those individuals would be able to regulate employees, period, no matter where they are, even at their home or whatever the case may be. But I don't think it's meant to do that, if I'm correct. I think what it's meant to do is just regulate them during their hours that they're at work under the authority of those individuals. If somebody would like to clarify that brought that.
Can't they carry them off of clinics and off the clock? Like some prosecutors do carry them all the time.
Do you, author?
Ms. Taylor, would you like to?
Thank you, Mr. Chairman. Yes, what about those that are carrying weapons when they're off duty? These could be court officials, and they could be currently carrying, and I just want to make sure. Sometimes they would be using them, but they're not, 9 to 5. Maybe they get called in the middle of the night or whatever. I want to make sure they still have that right, and they aren't. I mean, you just can't say for 8 hours or on the clock.
I think you and I are fighting for the same thing.
Yeah.
Okay.
Okay.
I think this was prepared by the Prosecuting Attorney's Council, isn't it?
Yes, sir. I think if you look at 1 and 2 have just similar language. I'd like to just throw out, most of these are, there is a time when they do work, but most of, especially sheriffs, deputies, police chiefs, and there are people that are under them in a law enforcement agency, they're even acting on private time with the weapons that are provided for by those appropriate agencies. And if I remember the discussion, Representative, that was why it was written that way, because they are.
Okay.
And they're underneath, they're working that post-certification that way.
Okay.
All right. We have a motion and a second. Any further comments or questions from any committee member? If not, all in favor say aye. Aye. Opposed? Very good. All right. Amendment 4. Line 612. This was the language that struck the 3 words "in a holster," where it would read "shall be carried on the person and not in a purse, briefcase, bag, or other similar accessory." And I will make that motion. Do we have a second?
Second.
We have a motion and a second. Do we have any discussion? No discussion? All in favor say aye. Aye. Opposed? Ayes have it. We have Amendment 5, line 370. Ms. Waits, I'll recognize you for that.
Yes, sir. Line 370, we would leave that provision in it. That we won't strike it.
All right. We have a motion from the representative to return number I back to its original language of the pointing of a weapon or a gun or a pistol. Do we have a second? We have a motion. We have a second. Do we have any questions from any committee member? Any comments? Yes, sir. Representative Dalton.
Is she leaving it like it was from the beginning?
No, she's striking it. This takes it out.
Period.
She's putting it back in.
Oh, she's putting it back in like it was?
Yes.
Oh, okay.
Returning it to original language. Any further questions?
Mr. Chairman, if I may.
Yes, sir.
I think I would like to see us leave it as is in our proposal, that that is redundant. This offense is already greatly covered by the definition of aggravated assault.
All right, do we have any questions? If not, all in favor say aye. Oppose? No. All right, let's have a hand vote. All in favor of that amendment, raise your hand. 1, 2, 3, 4. 4 ayes. Opposed? 1, 2, 3, 4, 5, 6, 7, 8. The motion fails. Amendment number 6. And you, counsel, you'll have to read this one for us, please.
Amendment number 6 will be in section 1, section 1-7. Obviously, line number. Hold on 1 second. It will be. It will go in between line 336 and 337, and this will be a new subsection A.1, and it will read, any person applying for a weapons carry license after July 1st, 2014 shall be required to demonstrate proficiency in loading, unloading, and shooting a firearm. Any gun range licensed in this state shall be authorized to conduct such a basic firearms competency test. The fee charged by such gun range shall not exceed $35 for such firearms competency test. Any current or former peace officer or military personnel shall be exempt from this subsection.
There you go. That's a mouthful. Anyone, Ms. Waits, do you want to make the motion on that?
Do I need to restate it, sir?
Would you like to make the motion?
Yes.
Without having
Sure.
to reread
I'd like
it?
to make that motion.
All right, we have a motion. Do we have a second? We have a motion and a second. Any questions concerning the amendment from any member? Any comments? Ms. Taylor.
I want to make sure I understand. What would happen? Are we telling these gun owners, the gun shops, that they have to do it for $35? What if you can't get a testing or a class done for $35? And what criteria are you going to use for the people to be providing the testing? Are they going to be certified officers? Do they have to have some kind of background or certification themselves to be able to be an instructor? And what if you can't get one for $35? Does that mean it's been waived?
I'm happy to look at that. I'm asking any licensed gun range to be authorized to conduct such a competency test.
Right, but they could have an employee that's not really certified in instructing, and then what do you do? I mean, are you just letting anybody? It could be the doorkeeper do the test. I would think you would demand that you would have somebody that is certified as an instructor. And again, what happens if it costs more than $35 to conduct it? Is it then waived? You don't have to do the testing. It's not clear to me in the law.
I would certainly be open to amending the law.
Well, this would be the proper time for any amendments to the amendment. If not, any further questions? Representative Atwood.
No, it's the old button, Mr. Chairman.
All right. Are there any amendments to this amendment? Are there any further questions on this? If not, all in favor of this amendment, say aye. Aye. All opposed?
No.
The nays clearly have it. The motion fails. Now, the posture that we are in, there's been 4 amendments to the bill. Is there any further amendments by any committee member? Any further amendments? If not, we have a motion on the bill as amended as a committee substitute. Are there any further questions? If not, all in favor of LC 410182S as amended as a committee substitute. All in favor say aye. Aye. Opposed? Do we want a hand vote on that? No? I think the ayes clearly have it. Ladies and gentlemen, this meeting is concluded. I want to thank all of the people who participated on both sides of this issue, and thank you all for your courtesy.